This week in U.S. immigration news, we are going to cover: DHS began limited implementation of DACA under final rule, USCIS announces online filing for affirmative asylum applications, Venezuelan migrants in legal limbo, 6800 Venezuelans have been approved to come to U.S. legally, advocates ask Biden not to send Haitian migrants to Guantanamo, migrants' documents being confiscated by border officials, Special Immigration Services injunction narrowed by 9th CIR. October 31, 2022, the DHS final rule to preserve and fortify DACA went into effect. This implementation means that DACA is now based on a formal regulation, thereby preserving and fortifying the program while it remains the subject of litigation in court. DACA was previously based on a policy memorandum that was issued on August 15, 2012. Under the final rule, USCIS will continue to accept and process applications for deferred action, work authorization, and advance parole for current DACA recipients. Due to ongoing litigation, the agency will continue to accept but cannot process initial DACA requests. The 589 form is available to file online for certain affirmative asylum applicants. The agency has decided to make this form available to file online to have its operations run more efficiently and effectively. USCIS will continue to accept the latest paper version of this form by mail. To file online, the applicant must first review the instructions on the USCIS website to determine whether their application may be submitted electronically. To file an online Form I-589, the applicant must create a USCIS online account, where individuals are provided a secure method to submit forms and track their status of pending USCIS immigration requests throughout the adjudication process. The Biden administration recently announced a new change to its immigration policy for Venezuelan migrants. Since 2015, more than 7.1 million people have left Venezuela since 2015, mainly due to the country's humanitarian crisis. This year, 150,000 Venezuelans have arrived at the U.S.-Mexico border. Last month, the Biden administration announced Venezuelans who cross the border without authorization will be returned to Mexico. Mexican Foreign Minister Marcelo Ebrard said the U.S. deported 1,768 Venezuelans to Mexico within the first week of the new policy. Those sent back to Mexico have limited job opportunities and only a small amount are able to gain stable employment. The program began on October 18 and the U.S. has had approximately 490 Venezuelans arrive in the country legally under humanitarian parole. The Biden administration reached a deal with the Mexican government, allowing U.S. border officials to expel Venezuelans that entered the country illegally to Mexico under Title 42. Since the implementation of this new program, at least 6,311 Venezuelans have been expelled to Mexico. On Friday, over 280 immigration, faith-based and rights groups sent a letter to the Biden administration requesting that they do not send Haitian migrants encountered at sea to Guantanamo Bay or a third-party country. Biden administration believes that once Haitians are able to buy gas again, there may be a mass exodus of migrants traveling to the U.S. by boat. Advocate groups were responding to the model scenarios in case of a surge of Haitian migrants which were released by DHS. The letter urges the administration to instead allow Haitians to be removed from the vessels at sea and then be sent to the U.S. to claim asylum. U.S. Customs and ICE are reviewing their policies and practices to ensure that once a migrant is released from their custody, they will be given back their documents. Migrants reported to 60 Minutes that CBP officials along the U.S.-Mexico border kept their documents, even though the agency policy instructs agents to return the personal property of migrants unless they are fraudulent. The accounts by these migrants have prompted Democratic reps Benny Thompson, Joaquin Castro, Raul Grijalva and Nanette Barragan to ask the Government Accountability Office to conduct a review of CBP's activities, policies, and procedures regarding the handling of personal property belonging to individuals in its custody. Last week the Department of Homeland Security lost in the Ninth Circuit in its attempt to undo an injunction requiring Citizenship and Immigration Services to comply with statutory requirements for processing petitions for special juvenile immigration. The U.S. Court of Appeals for the Ninth Circuit upheld but narrowed the injunction by saying a one-way tolling provision was unreasonably broad. The court may modify the struck tolling provision on remand.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our CARES team and they will help you get scheduled with our legal team. Now here's a secret code to unlock the free 15 minutes.